Yeah, so I think we can go ahead and get started. I just want to welcome everyone. Thank you so much for joining today. I'm really excited about this presentation. It's been a long time coming, and I'm excited about sharing all my thoughts with you. So maybe we can start off telling everybody about our Vision AI Law Group. We have a dedicated team who's standing by. We're happy to help with any AI issues you're confronted. We all have very diverse backgrounds. We've joined forces with AI Consulting Group, so we can also provide you with other great services. So please check it out on our website. I'm going to talk a little bit about me, which is always fun. So I just want to say that before we dive into this transformative world of customer service and customer experience, I just want to tell you a little bit about me. I've been an advertising attorney for my entire career, and I've been focused on helping amazing clients achieve their business objectives and also ensuring that advertising, pricing strategies, and product claims are compliant with ever evolving regulations. And for me, there's just something deeply satisfying about solving these puzzles for clients to bring these innovative products and services to the marketplace. I was product counsel before that was even a title. And I just have seen a lot in this space, from working on advertising campaigns, competitive challenges, NAD challenges, court battles, FTC, states, and the list goes on. And I'm going to talk a lot about that today. And I just was reflecting last night that, like, just when I thought I had mastered one technology, we're on to the next one. And I'm a lifelong learner, as you know, from the series. So I've learned a lot in the last year, especially from my colleagues Brian and Diana. Been very helpful about AI. And I'm really excited to talk about AI in advertising, customer service, and online interactions. I think it's really crucial for businesses as they're navigating this landscape today. So let's explore a little bit more. Also about me, I'm speaking next week at the SOCAP National Conference. And also be talking about AI in customer service. I'm really excited for that. Be covering some different topics than I'm talking about today. So we can go forward. So today I'm going to talk about advertising law, AI in the customer experience, what the regulators are up to, some enforcement actions, and then some best practices. And then hopefully we'll have some time for some questions. So please feel free to put them in the chat. We'll check that at the end, and we're happy to answer any questions we can. Let's get in the next slide. So what is advertising law? It's a body of regulations, and it governs promotional communications across all types of industries. For me, like, I watched the Super Bowl for the ads. I've always enjoyed advertising since I was younger. But I think really at its core, it's making sure that there's truthful, fair, and not misleading advertising, and also protecting consumers from deceptive practices. And what makes this area very important is that it encompasses multi-layers of oversight, as I was talking about earlier. So we have federal regulations, we have state laws and industry regulation. And while AI may be new, these fundamentals still apply in this new technology space. And the FTC and other regulators have made it very clear that AI is no exception from truth in advertising. So we can go forward. So let's just talk about advertising 101. So as I said it over and over again, and I probably can't say it enough, your advertising claims must be truthful and not misleading. So what does that mean? You have to make sure objective claims are substantiated. So that means that they're supported, that there's evidence for them. And you have to provide that substantiation, hopefully to legal or somebody looking at your ads before you put them into the marketplace. Objective claims need to have a reasonable basis and a level of proof increasing with the specificity of that type of claim. So another one is clear and conspicuous. So I have a bulldog. She loves to play with the ball. Let's not hide the ball. You need to disclose all of the material facts. So what are material facts? Those are things that are necessary for the consumer to make an informed purchase decision. So price, but they might also want to know taxes and fees that go along with those prices. So those are the examples there. And then the last is fairness. So comparative claims, those are when you're comparing to your competitor in the space, and you need to make sure that those claims are substantiated, as we mentioned earlier. And you really, should try not to disparage competitors without evidence. And I think while these principles may seem straightforward, applying them to sophisticated AI systems is definitely creating new challenges. You can go to the next slide. So substantiation, this is something that I've worked on through the years. And basically, there's different types of claims. So if you have a general claim, you're going to need to have a reasonable basis. So an evidence of support or something objective that can back up your claim. I think it has to pass the smell test. And then if you have specific performance claims, you're going to want to have robust evidence for that. So some examples are prevents odors. You need to make sure that you have more than just a reasonable basis. You're going to want to have like studies and things like that. We talked about comparative claims. Again, you're going to want to have head-to-head testing when you're making a best claim, although we'll get to puffery. And then establishment claims are more about scientific proof, like studies show, and then you have absolute claims, which are 100% effective, and those have a very high bar. So let's look at some types of claims. We can go to the next slide. So this is an express claim. It's a Minute Maid. They're saying juice boxes are good for you. So you probably want to have some support for some of these things, like 100% natural flavors and no colors added. So you want to make sure you have the testing that shows that no sugar added. And then you're going to want to disclose anything that's relevant to that. So, even though it has no sugar added, it's not necessarily a low-calorie food, is what they're disclosing here. So another claim is implied. So in this case, it's TurboTax, and they're telling consumers you're going to file your federal and state returns free, simple tax returns only, and see if you qualify. Well, it's not exactly for free. You will still have to pay for the software. It's just that they mean that the filing itself is free. So they needed to make that a little bit clearer. This advertising is now out of market. It was challenged because it was unclear. Another one that we see is when you're leaving out information. So you're leaving out critical information I was talking about earlier. So maybe it's not just $100, it's $100 plus taxes and fees. And the longer you hold that gift card, the money starts depleting. It's things like that that consumers need to understand. They're not getting something for $100. And then last, inadequate disclosures. This is an influencer campaign. An influencer was wearing a particular brand of sneakers, and they failed to include any disclosure about a material connection with the advertiser. The FTC, the Federal Trade Commission, has a whole guide on influencer laws and disclosures. So this was just an example of one where that just did not get added. It was challenged and it was ultimately taken out of the marketplace. You can go to the next slide. So over the years, many of my clients will come to me and say, oh, that claim doesn't need substantiation. It's just puffery. So I think for me, the classic puffery case is this Papa John's case. What is puffery exactly? So it's just subjective or vague promotional language. that no reasonable consumer would rely on as having a factual basis. But I think one of the things we know is that the line between puffery and actionable misstatements is very thin. So in this Papa John's case, the slogan "Better Ingredients, Better Pizza" was initially ruled as an objective, provable claim requiring substantiation. However, later in the court process, it was later determined that it was actually puffery when standing alone, because nobody could reasonably think that this was actually true. A more recent case involving puffery too, actually, related to Upstart and General Motors. But in this specific Upstart case, the court found that some of their advertising that said that AI was fairly magical were non-actionable puffery. However, if they had claims that said that their AI had a significant advantage over other models, that needed to be supported. So you needed to demonstrate with verifiable evidence that it was truthful, or otherwise it would be actionable and maybe ruled as false. So this is a distinction that's critical for companies, especially new entrants, thinking about your claims and making sure you're not making an objective claim without substantiation. And you should really test them and make sure that you're not running into potential liability. So we can go to the next slide. So what makes a practice unfair or deceptive? So the Federal Trade Commission, when they're evaluating advertising, they'll look at it, the practice is either deceptive or unfair, and then sometimes both. So under Section 5 of the Federal Trade Commission Act, a practice is deceptive when it involves, one, a representation, an omission, or a practice; two, that it has a interpretation that is reasonable, and the misrepresentation is material to the consumer's decision. And I didn't say this in one, but it misleads the customer. And then unfair is a different standard. So it's going to look to see if the practice is likely to cause injury, and it can't be avoided by customers, and that there's no, that's going to do a benefits analysis to see if the benefits possibly outweigh the harm. And so that's how the Federal Trade Commission, who enforces most of the advertising I've dealt with over my career, looks at these things. So let's look about advertising in this space. So there's a new term, the FCC they had a Operation AI washing. They were going after different companies for deceptive claims in their AI advertising, send out multiple letters. They filed lawsuits in certain cases. One of the claims that you see here is the world's first robot lawyer. They were talking about that it could do all these great things, and it actually couldn't do those things. So it was really overstating what AI can do. And then in another case, this one, the next one is Ascend, and it was a case where when you often are on Facebook or other things, you're in the funnel and you see these great advertisements for all the wonderful things you could do. And they were offering like an expedited path to get on Amazon and Walmart's e-commerce platforms. And they were offering that customers could make, $10,000 a month. And when in truth, in fact, they weren't able to do that. So the FTC went after them for this, and they modified their claims. A couple of other examples is just misleading demonstrations. So your demonstration does not actually reflect how actual product performs. I mean, sometimes you might see even disclosures on the screen that say, like, even when something is driving, so like a truck driving on, top of the Grand Canyon, like it's not actually a realistic representation. The advertiser will disclose that, but absent that, that might be more problematic and be sending that implied claim that I talked about earlier. And then last, just false superiority claims, we're the best. We have the largest network. We have the best network. My background is obviously in wireless technologies. So there was a lot of fighting between the major carriers about who had the best network. I believe that's still going on now. I can go to the next slide. So just here again, just key points I've already talked about. I'm not going to spend a lot of time on this, but I did want to point out something I saw. 94% of consumers believe all AI generated content should be disclosed. So even when you are thinking about using AI generated content or trying to augment it, there's still a demand, and we'll talk about this a little bit later, that the consumer wants to know. And I was speaking last week at another function. I was saying that I think sort of setting aside the legal issues, being transparent in your communication builds loyalty and it builds trust with your customers. So I don't always think you should approach it thinking of, oh, this is the lawyers are telling me I have to do this. I think sometimes it's really helpful if you can actually put yourself in that consumer's position and think about how you might react if it was you. Okay, so we can go ahead and go to the next claim. So AI is regulated at many multiple levels. We have federal agencies, we have state authorities, we have industry self-regulation. And then another thing I just wanted to point out is Facebook and Instagram and LinkedIn, they all have their own platform rules. And as an advertiser, you should be checking those as well to make sure that you're not doing anything that's running afoul of those policies. So can keep going. So what are top concerns? Some of the bigger concerns are proper disclosure of AI generated content. So businesses these days are required to disclose, in some cases, when AI is used to create or modify advertising, marketing, or customer-facing content. There's some pending laws on that, and then just others from enforcement where we're seeing that. And there's rights of publicity issues. So what does that mean? It means that when you're using someone else's image and likeness, you need to make sure that you have the right contracts in place and the licenses. You don't want to use someone's voice or face. There's been a lot of cases where actors have challenged people just taking their picture, walking out of a pharmacy, as an example, because they weren't licensed. That was Dwayne Reed and Gwyneth Paltrow. Some other things to just think about is how you might be using AI in content creation. And it raises a lot of copyright questions, and I know we covered that 2 classes ago. It's just something to keep in mind also when you're thinking about sort of your advertising campaign. And then also just considering the potential for deception. I mean, I think most brands have good intentions. I think sometimes there's implied claims that you're just not necessarily thinking about, or you're not evaluating it in that way, or so it's helpful if you do have a legal advisor to look at it just to see if there's things that maybe you haven't thought about, or if you run around the office and ask different people what they think about it, so that you can make sure you're substantiating all types of interpretations. I think another thing that I think is very challenging for businesses in this space is that you also have industry self-regulation. So in addition to the FTC and states, you also have industry that will give you guidelines, or they will give you actual decisions. And we'll talk about one a little bit later, but it's under the Better Business Bureau, and it's called the National Advertising Division. And you can forego bringing court claims and submit your advertising challenge to this informal regulatory body, and they will decide it for you, and you're bound by that. And then advertiser will decide whether or not they're going to honor the decision. They have rights to appeal it. And then they can, if they don't follow it, sometimes the NAD will refer that to the Federal Trade Commission for an actual enforcement review. One of the big things that we've been seeing lately, and I think it came up certainly in the 2024 election, I haven't heard about it during this election season, maybe others have, but it's the deep fake. So there was the example of the calls that Joe Biden allegedly made in New Hampshire to right before the primary wasn't actually him. So we're seeing a big trend in the states to make sure that businesses are disclosing that it's AI generated voice, and that they're also making it clear that it's not the person they say it is. And then we got into the rights of publicity issues, making sure they have the rights to use the voices. You can go forward. So another thing that's really interesting in this space is that we're not seeing just the FTC enforcing here. We're also seeing activity from the Securities and Exchange Commission as well as the Department of Justice. So in 2025, the DOJ and the SEC filed an action against Nate Inc. They allege that the founder falsely claimed proprietary AI automated online purchases when in reality, overseas contractors were manually processing the transactions. The founder had staged deceptive product demonstrations and they had raised over 42 million in investments based on these misrepresentations. So another example is Delphi and Global Predictions. Again, they were misrepresenting their use of AI in filings. Global Predictions had falsely branded itself as the first regulated AI financial advisor. And they were also promoting non-existent AI-driven forecasts. So for that company, the combined penalties totaled over 400,000. Plus a compliance consultant requirement. So they actually have to have someone come in and look at their advertising. These cases are also notable because they show potential for both civil and criminal liability when misleading investors about AI capabilities. So it's important that you're not only thinking about what you're putting out there in your advertising content, but what you're putting out there in your press releases, what you're putting in public filings, what you're saying in statements, and the representations you may even be making to encourage investment in your products and services. We can go to the next slide. So another area where we're seeing a lot of enforcement is state attorneys general. And they are actively applying their consumer protection laws to AI marketing and implementation. Both the Massachusetts AG and the California AG, Rob Bonta, they've issued guidance to their residents saying, and to industry saying that their unfair and deceptive practices laws govern in this space. And that you need to make sure that you're not violating those laws. They're not going to pass new laws because the existing laws apply. In Massachusetts in particular, Andrea Campbell issued an advisory clarifying that they're going to focus on unfair or deceptive practices and addressing potential discrimination using existing laws. And then I think something that's very notable is Texas was one of the first states to enforce here. So Peace is a healthcare AI company. And they allegedly made false claims about product accuracy. They were promoting the ability to minimize AI hallucinations with a claimed rate of like less than 0.001%. And that was not supported. So they are now under settlement. They have to pay a fine. And they also now have going forward obligations. So a lot of times when you settle as a company, it's good because you're not going through the whole investigative process. Litigation can be costly, but it also means that and in particular with the FTC, you're subject to rules of the road, sometimes for up to 20 years. So it's important to get these things right if you don't want to have that oversight. It is cumbersome for businesses, especially in the technology space where things are evolving and the law often can't keep up. So you can go to the next slide. So beyond regulatory enforcement, we are always delighted with our friends, the plaintiffs bar and private litigation. It's another way to keep businesses honest. So we have a couple of cases, and one of the big trends that I in particular have been following is platform liability. So not just focused on the actual advertiser, but actually the platform where that advertisement ran. So in this Forest case, the court examined whether Meta's AI-driven tools materially contributed to scam advertisements, and they focused on platform liability for AI-enhanced targeting. And so it was interesting that they looked at that. And then in a similar case, the Facebook case, this case addressed Facebook's development of AI for content curation and advertising technology. And the court examined the platform's responsibility for AI-powered advertising systems and content moderation. And they established standards for the content filtering and disclosure requirements for Facebook going forward. So it wasn't so much about whether they were running something that was a scam advertisement and not taking any action, but it was really more about how they were using AI for content moderation and things of that nature. And then, of course, there's the OpenAI and OpenAI case, and it was actually in 2024. And it's centered around a trademark dispute between the names. And the court granted a preliminary injunction in favor of the actual one that we know, OpenAI, finding that its trademark was substantially exclusive and associated with widely recognized AI tools. And so this is another tool in your toolbox. So if you have a brand and you want to protect it, you should be out there enforcing and making sure people are not using your brand or diluting it. You also don't want them to be using it like as a common everyday word. I was actually studying business law with my oldest son who's in college last night, and we were talking about this very thing. And making sure that you were going after and protecting what we were talking about as an example, like a Kleenex. So, here's a Kleenex, people should be saying it's a tissue. So you want to protect that brand and not dilute it. Another example is actually a sound mark. So Nextel, for those of you who remember what that is a mobile company, and it had this amazing chirp. So it was a very distinctive sound. And there was litigation over it because they weren't using that sound and they weren't enforcing it. So it had become diluted in whether or not it was still protected. We can go to the next slide. So I talked about this a little bit earlier. The National Advertising Division, it's part of the Better Business Bureau. It's an industry self-regulatory entity, and it really does work, and it champions truthful and accurate national advertising. You see a lot of competitors will enter into the process. They're able to submit, so the advertiser gets a chance to respond to whoever is the company that's challenging the claim. Then they have a process, and you meet with them and you argue your case, and then they usually issue a very sound decision. It's good precedent, something you can look at to get more information about advertising precedent. And in this case, NAD opened up its own inquiry. So it was an independent inquiry of Google's demonstration video of Gemini. And I'm sure many of you know that Gemini is a large language model. And the NAD was asking Google whether or not this video accurately depicted the actual performance capabilities. And it actually led to Google voluntarily removing the ad. NID has been forward thinking in this space. They've developed standards for AI advertising, accuracy in demonstrating actual capabilities, being very transparent about your system's limitations, clear disclosures when demos are simulated, making sure you have support for performance claims, truth in representing the customer experience, and fair and competitive comparisons. And it's sort of as a parting thought here, this self-regulatory approach can often address emerging issues more quickly than formal regulation, so FTC investigation or even court enforcement. And so it's really a helpful vehicle for marketers that are living in this rapidly evolving field. I can go to the next. So one of the things that's very controversial lately is AI generated content. Last week I was watching about there's this new actor that's actually all AI generated, and that's causing a lot of controversy. We're also seeing this in actual print advertising. So here's an example, J. Crew, they used an AI generated image. There's growing use to create virtual influencers or these synthetic models. And it's raising a lot of concern amongst consumers that it's harmful, it's sort of diluting or taking away from actual models, and is it really representing what people look like? Sort of similar issues, but now you're actually creating it yourself to look real. It's also this trend discussing making an advertisement look like it, this person looks like they're having a beautiful day, they're perfect. And not everyone looks like that. And is it really a fair representation of what these things will look like on them? I think another thing is, we know that brands are looking to AI to save money in any way that they can. And it does perhaps lower costs, but at the end of the day, it might actually backfire, and consumers may not want to be a part of your brand because you weren't forthcoming. And I think just as we talked about earlier, sort of these legal and ethical considerations, just raising concerns, job displacement, misrepresentation, and consumers being confused. And even the models themselves are objecting. So another big topic, and it was a big topic in September, especially for regulators, is just using a chatbot. Chatbots have their own unique compliance challenges. Hopefully many of you have already included in your chatbots that it is a chatbot, and that you're collecting information about the person and that you might be using it for other purposes. But it's important to make that very clear up front. There's state laws that are emerging with that. The FTC has specifically warned against hiding the nature of AI customer interactions, and businesses must provide an easy escalation path to a human representative when needed, and maintain consistent identification of AI across service channels. Another consideration here is data privacy. So you should make sure that when you're using these chatbots, you link to your privacy policy, and that you have very clear notice of data collection and processing for service personalization required under the various privacy laws. So some of the complaints sort of on the business side, so apart from the legal side, is just that if you're in the chatbot, you're just trapped there. There's no path to a human. It's frustrating that they don't provide the right information. They give you wrong FAQs or irrelevant. They might tell you that your return policy includes a yacht for you. I mean, just joking there. But it really can go out of bounds. So having a human in the loop is really helpful. I talked a little bit earlier about the first human robot. That's a do not pay case. and it really illustrates the risk of overstating chatbot capabilities. There, as I was talking about earlier, it was saying that the AI lawyer could replace the $200 billion legal industry, which, I mean, maybe it can, I hope not. But the FTC alleged that the service couldn't deliver on these promised capabilities, and it used it as an example of demonstrating the dangers of capability exaggeration in customer service applications. So let's go to the next slide. We can talk about some best practices for remote AI. Yeah, this is actually, sorry, it's notable examples of customer failures. So I think in other classes, we've talked about this notorious Air Canada case where a consumer was on the chat and they were asking about a refund policy for bereavement, and there was a hallucination given and the wrong price was given. And ultimately, when that consumer went to purchase the ticket or whatever, it had a higher price, and that the consumer ended up suing and winning. The court in the tribunal in Canada held that that company must honor that price. And another case that we've seen is Klarna, and this is actually particularly interesting because Klarna was out there touting the benefits of AI and how it was going to help them, and they reduced their workforce. And then what they realized is that their AI assistant was actually going off track quite a lot. And so they started introducing, humans back into the loop. So again, AI augmentation may be useful, but it may not be the holy grail for your customer service solutions, and you should be monitoring it, especially as AI is still emerging and new. Here, this cursor case, the bot was actually just making up policies. So they were just telling the consumer, this is what your return policy says, and there was no truth to it. It was all inaccurate. Another example is Chevrolet. And I really kind of wish that I'd actually been a part of this chatbot, because the chatbot was selling cars for $1. And I would have liked to have taken advantage of that. That would have come in handy. And so, Chevrolet had to backtrack and do damage control there, honor prices, and it was just not profitable. There's another example here of the DPD delivery chatbot, and the chatbot, when it would get frustrated, would swear at the consumer, or you could trick it into swearing with you. And so that was something that was taken down and corrected. And then lastly, we've all gone through the McDonald's drive-through, or at least many of us, and it would be great if there was a bot on the other end that could handle faster order times. But even McDonald's has found that the AI bot was just not capable of getting orders correct. There was a lot of frustration, and they pulled this trial. So, sort of best practices in this space. We've talked a lot today about different things to think about, particularly as you're marketing your products and services. I just want to highlight some key things for you. Existing advertising laws apply in this space. And so you want to make sure that you're complying with those laws, which is, truthful advertising, clear, inconspicuous, and trying to be fair, especially with comparative advertising. Another thing that's very helpful for businesses in this space is making sure that they're developing internal policies on AI content and use. It is important that you have a process to submit that, if you have a legal department, for them to take a look at and to help you evaluate those claims, to make sure that you also have appropriate licensing rights and those things, and that they've helped you write disclosures and to minimize your risk. And they really are there to be your partners, and that's what I started off talking about. I liked it when I was in-house, and I would stay up late to try to help them launch a new advertising campaign in the morning. And there's just something so exciting about it. So the lawyers, they don't always want to say no, they want to partner with you. So getting to them early and often is very important for your product launches. And then another thing is just staying tuned because regulations are changing in this space daily. States have come out with all sorts of AI regulations. We're staying on top of it as best we can. We're seeing legislation being passed, and it's just trying to drink from that fire hose fast and furiously to make sure that you're able to meet those obligations. And we know that states are watching and they're enforcing. We talked at the top of the hour again about substantiating your claims. I've seen it time and time again where a competitor will challenge an advertiser's claim. They'll either do it indirectly while sending a cease and desist and hoping that that advertiser will voluntarily take it down or that it will escalate. And seeing that play out in the press isn't always necessarily great for customers and their faith in your products and services. So it's good to have substantiation upfront and making sure that it stays substantiated while it's in the market. So sometimes your claim, you may be the largest network today, but you may not be the largest network tomorrow. And if you're not, you should be proactively pulling those claims out of market. Maybe you don't want to put them all over like print advertising and things that are difficult to pull. And then I just think, conducting regular compliance reviews is very helpful. And then considering both the consumer expectation and the legal requirements, as well as just trying to keep a human in the loop, especially right now. So you can go to the next slide. I just wanted to give a shameless plug for the newsletter that I send out every month. It's called In Case You Missed It. We just put out issue number 2, and the QR code is here. So feel free to subscribe today. You can go ahead and go to the next question. So next time on October 21st, my colleague Brian Alexander and I are going to talk about the EU AI Act dissected. It's a big chunk of information to digest. So I'll just be giving you a high level presentation of how you can manage compliance for AI in Europe. And again, that's the 21st, and can register using this QR code. And I'm just going to open up the floor to see if there's any questions. Well, it doesn't seem like any of you have questions. Thank you very much for the nice words. And hopefully if you do have questions or you think of things or you're working on a campaign, don't hesitate to reach out. You can find me here. It was great presenting to you. Really appreciate it.